Saigo everyone, Chief Sherri-Lyn Hill here. Nyawa, thank you for tuning in to the weekly Chief and Council radio show. This week, I am going to tell you about some of the news and events going on in our community. First off, huge congratulations to Brandon Montour for winning the Stanley Cup. Seeing you raise the Stanley Cup and represent our community with so much pride means a lot to all of us. And to see the community gather and support you is something we will always remember. All the money raised from the lawn signs and the t-shirts in support of Brandon are going to Six Nations minor sports organizations. We're all happy for you, and again, congratulations. Now, this week, we'll have inspiring words from our guest and Lands and Resource Director, Lonny Bomberry.
Good day, everyone. This is Lonny Bomberry. I'm the Director of the Lands and Resource Department for the Six Nations Elected Council. One of the duties of our department is to help manage the huge court case that we have against Canada, Ontario, and recently added the Mississaugas as a new credit First Nation. Our claim, it's been in the news for quite a while now, since and it was started in 1995. Originally, it was characterized as a land claim, but in effect, it isn't actually a land claim. It's a claim for damages for breach of fiduciary duty in a manner that the Crown illegally took our lands in the late 1700s and early 1800s up to the first half of the 1800s. There was really the lands that we lost, that Six Nations lost, were not lawfully taken in our opinion. In many instances, because it involved a number of different transactions, and if it could be said that any of the transactions are valid, then the terms of the so-called surrenders were never truly fulfilled, such as the fact that there was supposed to be lands were supposed to be sold at certain prices. In a lot of cases, they weren't. They were either sold at lesser value or actually given away, and so that's the instance of that, as well as our land rights here where we are now are based on the Haldimand Proclamation, the document of 1784, and that document essentially says that Six Nations is to have this land what we once had and where we presently are still situated in a small degree along 6 miles on each side of the Grand River from its source, which is up near Dundalk, Ontario, to its mouth, which is at Port Maitland into Lake Erie. And the bad part about it is that was the wording of the Haldimand Proclamation, and it was never fulfilled. We never received about a quarter of that land that was stated in the Haldimand Proclamation. That is that land in the northern part of the tract. We call it the Headwaters Claim, from Pensley Nickel Township on up to Dundalk, which is about over 200,000 acres that was never given to Six Nations, in spite of what it said in the Haldimand Proclamation. So we are holding that the Crown to that task for failing to do that, as I said, the claim, I didn't say it, but the claim is not about return of land. That would be practically legally impossible to do because we're talking about 950,000 acres. Land has been out of our control now for some cases over 200 years. And it's unlikely that any court would see fit to give us the land back free and clear of all those third-party owners within the tract, which are thousands, if not millions. We don't know how many that is. But the manner in which the Crown took those lands, illegal as I said, and any monies that were recovered, they misappropriated to their own uses. Six Nations never realized the benefit of any such land sales. The maximum benefit, they realized a little bit, but the trust money was misappropriated by the Crown and spent on their own uses, since they were the trustees of the land. And so we're asking that that the Crown be made to account for that. What we had stated, and we've always maintained, that that the Holloman Proclamation is a treaty. As a treaty, it created a reserve for Six Nations, a reserve in the traditional sense, and it was land that's set aside for a group of band or a nation of Indians. And that's what we say the Holloman Proclamation effectively did. And in doing so, in doing that, the creating a reserve, the Crown is the trust. Crown responsibility is a trustee responsibility, like for managing that trust, managing that land, and if they breached any of their duties in doing so, as a fiduciary, we say they're a fiduciary because they're in trust-like position, then damages flow from that breach of fiduciary duty, and that's been a long-established law now in Canada that the Crown is fiduciary of Indian Reserve lands by a number of court cases decided by the Supreme Court of Canada. So we're alleging that. It was always that what we alleged in 1995. We made it more clear in the recent amendments to our statement of claim that was done in September of last year, 2023, in which our statement of claim was amended to make that more clear that that's what we're asking for. And I also said too that we're saying that they're trustees. Fiduciaries are trustee-like bodies, and that they, in being a fiduciary, failed to protect the lands and money that they were fiduciaries of. Certainly, as I said, it indicated the lands were taken in some cases without any compensation or without any surrenders. And I'm thinking, like, you take Oneida Township, there was never no surrender for that whole township, and others like that. So their fiduciary duty is has been breached in not doing the proper legal requirement, fulfilling the proper legal requirements of what they should have done. And also a lot of the monies that we did receive from any land sales, they misappropriated. We've indicated, money that went to the Law Society up in Canada, money that went to the McGill University, money that was used to build roads in Ontario without our consent, and all these instances where the money was taken and not properly used for the benefit of Six Nations. So that is essentially what the trust accounting is. That's the other part. Not only are we alleging they breached their fiduciary duties, but because they once had this property that we and trust for us, and we no longer have that property, we no longer have that money, we are unaware, well, we are aware in a broad sense, but we are not totally aware of how it was lost. And they, as the trustees, have an obligation in law to account for their actions and in taking our land and taking our money. We don't believe that they can do that, but we're asking for them to account for that. So as I said, the case is not for a return of any of those lands that were taken, but to account for the manner in which they administered it, the manner in which they lost it, and in terms of any money that were recovered, the manner in which they misappropriated. So that's the court case. As I said, it's been going on now since 1995. For some period of time, there was a period in 2004 to 2009 when the court case was put in abeyance, which means it was stopped, and with the intention that our representatives from Six Nations at that time would talk with the Crown officials and try to resolve the lawsuit without the need to go to court. But that did not turn out to be the case. It never did arrive at any fruitful resolution of any of the claims, and it was overtaken by the Douglas Creek matter in 2006, and so it was essentially sat in abeyance, as I said, for about 5 years. But in actual fact, the effect of putting it in abeyance meant we lost approximately about 10 years in the lawsuit itself. So it began to pick up steam again after 2009. But as I said, it's a case that involves 250 years ago. there's no actual witnesses who can testify about the loss and about the breach of fiduciary duty. So we have to rely on documentary evidence. We have to rely on historical experts who have done the research and are able to give opinions on what occurred. And so it is a huge documentary case, thousands of documents, and that process of getting ready for trial means we have to obtain those documents. We have to make allegations respect to what those documents reveal and base our claim on that. And the Crown also has the obligation as a defendant to do their own individual research and to find their own documentary evidence to bolster any defense they might have, and in some respects to tell us about that and tell us what they have uncovered. Although it's not since we're the plaintiffs, we're the ones who are prosecuting the case, the obligation is on us to show what was done and the wrongdoings that were done in order to account for all the losses that occurred. So that process took a long time. Again, after 2009, it was pretty much essentially complete, although not totally complete, by 2018. And so then we began to push for, let's now set this down for trial and have the matter determined by the trial court. And so we began to prepare for putting it on for trial. And we've had some very understanding and case management judge appointed the cases. These are case management judges are the one who are going to oversee the case until it reaches trial. They're judges, but they're not going to be the judges that are going to the judge or judges who are going to be trying the case in the trial. So they have been managing the court case from about 2018 to the present. We've had two different case management judge. First one was Justice Sanfilippo, and the most recent one we had since one of the last couple of years is Justice Akbarelli. And they're very understanding, I said, and they know that about the need for this case to be resolved, and they have been very helpful in pushing the Crowns, that's Canada and Ontario, to get ready, to quit delaying and get ready for the trial. However, that has not been, although the judges have tried that as much as they can, there are still a lot of ways that the Crown can use to delay the resolution of the trial. And I can understand why they would want to do that, because this case is so huge in terms of monetary damages. We've never put a figure on it. It's just that huge because it involves damages that occurred from 200 years ago and on after that. And as you realize, it's if there are damages owing and interest is owing, compound interest or equitable interest, however you want to characterize it, after a while it amounts to a huge sums of money. And either Canada and Ontario, it's in their interest to delay it and not have to meet Judgment Day on determining how much the claim is going to cost them and how much they're going to have to pay. So it has been it has taken that. We have seen their efforts recently to delay the things, and it's delay matters. We had hopefully hoped that the trial would commence this year in the latter part. No, actually, the latter part of 2023. That did not occur because of delaying tactics, and also too that when we, as the case was being prepared for trial, parties intervened to try to become part of the court case, and of course the first one was the Haudenosaunee Development Institute, the HDI. They brought a motion in the court case to be made principally the plaintiffs of the case and to oust the jurisdiction of the Six Nations Elected Council Band Council as the lead party prosecuting the case. We felt that was totally inappropriate, totally wrong, and especially since we had been prosecuting this case since 1995, and we're aware of what needed to be done and how to present it for the trial. And also the other party who intervened was Mississaugas of the New Credit, that's New Credit, our neighbor next door. They brought a motion to intervene in the court case, saying that they disagreed with our characterization of the Haldeman Proclamation as being a part of our treaty lands, the Nanfan Treaty area. The Nanfan Treaty of 1701, made with the British and the Five Nations. They said that that is not our treaty territory. This area is actually their treaty territory, or their traditional territory, as they say. But you know, in our court case, we were never alleging that point be made. That this, we were never asking that the court make a finding that this is our treaty, the Haldeman Proclamation is our treaty territory or includes part of our treaty territory. We never were asking the court to make a finding out of that, and we weren't asking the court to make a determination this is our traditional territory. We weren't asking for that, and so if they intervened and on that basis, and I don't think that wasn't a very wise thing to do on their part, because they could get an adverse ruling would help them. Besides, any decision made by the court, even if they said that it was our treaty territory, the Nanfan Treaty was our territory, or was our treaty territory, it would still not bind them because they're not a party to the court case. But nevertheless, they intervened, and we have to also meet their allegations in the court in the lawsuit. Although they have guardrails placed on their claim, they're not seeking any damages from the court case. And not seeking any kind of relief other than just to be acknowledged that this is part of their territory as well. So it really doesn't really affect what we're asking for against the Crown in Canada, but we'll nevertheless have to meet their allegations, and I think we'll be successful in that. As recently, the other thing that recently has come up is that in setting the case down for trial, there is a shortage of Ontario Superior Court judges in Ontario. I don't know how that occurred. The Ontario Superior Court judges are federal judges, meaning they're appointed to the judgeship by the country of Canada. So, and they do that for all the provinces across the nation. So. In this instance, Ontario, because they haven't, Canada hasn't replaced judges who have retired in the last little while, there's a shortage of about 25 judges, Superior Court judges in Ontario. And that has a kind of a really delaying tactic on our suit, because we can't get a judge appointed to try the case presently, nor can we have a judge appointed to do the pretrial of the court case. And so you know, we made this concerns to our case management judge, Justice Akbarelli, and she's trying her best to rectify that, to try to get the chief judge of the Supreme Court of the Ontario Superior Court to appoint a judge and a pretrial judge, and we're hopeful that something will come of that. But as the situation now stands, we don't have a judge and we don't have a pretrial judge. Of course, the case has been delayed now. We thought it might start in 2024 because of these delays that have been used principally by the fact that there's no judges to try the case, that we're now in a situation hopefully having the case come for trial in 2026. There is also the other matter, though, that Canada's 3 expert witnesses, they are going to be using to present their side of the argument, and their evidence are 3 elderly persons, three elderly and persons who are not very great health as well. So they were afraid that when the trial is being delayed, that these trials, because of their age or infirmities, would not be available to give evidence at the trial. So they brought a motion to have their witnesses give evidence before the trial actually starts, and that was just recently brought within the last year or so. And there was recently a resolution among all the parties, the lawyers for us, the lawyers for Canada, and the lawyers for Ontario, and the lawyers for New Credit to set the terms and conditions for this taking of evidence to occur. And that will occur in the latter part of September and in October this year. So it will be like a part of the trial that will be held before the actual trial begins. And so that will occur, as I said, this fall. We expect it will take at least three to 4 weeks to have this done, because the witnesses will have to give evidence under oath, and being led by their lawyers, the lawyers for Canada, and then we have a right to cross-examine those witnesses, just like in any ordinary trial. We don't know yet who the judge is going to be. It won't be our case management judge, and it won't be the trial judge who is going to be hearing the case in the long run. So, but it will be a similar type person who will conduct the hearing, and we need somebody to conduct the hearing because we need a person, a judge, to make rulings on questions that are being asked and any evidence that's being asked to be presented, and I guess the scope of cross-examination that we might use to question those witnesses. So you need somebody to manage the whole process, and I think we have an agreement on that. And as I said, I hope it's going to be, it will be somebody who has judicial experience who will do that. The other thing, that whole proceeding that is coming up this fall will be recorded, and so if need be, when the trial commences, the latter part down the road, that recorded evidence that was given by the 3 witnesses will be played at trial, so the trial judge can see the whole thing and hear the whole thing, and it will be part of the record of the evidence that Canada presents in defense of their court case. But that is something that is coming up, and I'm very hopeful that we're going to do very well in that process of Canada giving its evidence, and hopefully that it'll be once more inducement for the Crown to start talking about settling this case. And I mentioned the HDI tried to intervene in 2022, 23. We had motions, and New Credit, we had motions on those matters before the case management judge in May of last year, and it took about a week for those motions to be heard. In the end, we were successful in keeping the HDI out of the court case. As I said, the New Credit was allowed in, but on a very limited basis. They certainly can't affect the overall ask that we're presenting for our resolution and damages for the case. So they'll not share in anything like that. So we've, although the fact, we've done our best to prosecute it, we've done our best to keep the case moving. Our lawyers are very excellent in that regard, and very experienced and very knowledgeable of the court process. We still can't overcome the delays that have been imposed recently on us. So it's, as I indicated, it is a continuing worry that we like to see this thing started as soon as possible. But we're hopeful that instances like the motions that we already had in May and keeping the HDI out, and also putting guardrails on New Credit, and also successful in having our statement of claim amended to include the fact that the Haldeman proclamation is a treaty, and it created a reserve. That as a result of what occurs too at the hearing of the presentation of evidence of the Canada's Crown witnesses, that it'll be a further inducement for the Crown to sit down and talk about resolving this case without the need to go on for a trial, which would take a number of days to do. Our lowest estimate, it would be over 200 days to do the trial itself. So how much time that is and how long that'll stretch out. So there's always hope that somewhere this can be resolved without the need for trial. But if we have to go to trial, we're prepared to do so, and if we have to, sit in court for days and days and days to present our case and to defend any defenses that the Crowns might try to raise, we're prepared to do that. So the case is still there. It's not going away, and we're just keeping it moving as much as we can. And we have a great team of lawyers on that part. We have 2 different law firms that are handling it. One is Blake's Castle and Graydon, the law firm that originally retained back in 1995. And in 2022, we brought on the firm of JFK Law as work in partnership with Blake's, and they've been working very well, and they're very knowledgeable, and they understand Indigenous law to the maximum. So it is, and they understand court procedure as well. So it has been very helpful in the way that they have presented the case so far, and I have very good hopes that if we have to go to trial, they'll be very successful and very competent in putting our case and getting justice for the people of the Six Nations. Thank you very much for listening to me, and I hope to be, from time to time, giving you updates on the progress in the court case from time to time as we go along with the next several years. Thank you.
Nyawa, thank you for those words, Lonny Bomberry. And Nyawa, thank you for tuning in and listening to the Chief and Council Radio Show. Until our next episode, take care, be safe, be well, and be kind. Have a great week.